Hello, everyone, and welcome to today's webinar presentation, Labor Law for Employment Lawyers, What Every Business Needs to Know. Labor and employment law compliance often feels like a moving target. During today's presentation, Kyllan, Kershaw, and John Harper will delve into recent labor law developments that every employment lawyer or HR professional needs to know. Before getting further into today's topic, I'd like to take a moment to introduce myself and my organization, complianceHR. My name is Stephanie Zielinski, and I'm the Marketing Director. You may recognize my name from the invitation emails you received for today's event, and some of you may have emailed me directly about this presentation. To prevent a few popular questions from entering a Q&A box today, I'd like to let you know that this presentation will be recorded and it will be emailed to all of you. So please keep an eye on your inbox for an email from complianceHR webinars. Now, a bit about complianceHR for anyone who may be unfamiliar. complianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler. complianceHR delivers expert employment law guidance in a fraction of the time you'd otherwise spend with traditional methods. Our goal is to simplify the complexity of employment law, something we will learn a lot about during today's presentation. To achieve that goal, complianceHR offers a suite of technology solutions around critical HR compliance topics, like employee handbooks, overtime, independent contractor classification, onboarding and leave, among many others. But today, I would like to introduce you to our two most popular solutions, PolicySmart and the Reference Center. PolicySmart is a comprehensive employee handbook solution that provides you with federal and state compliant templates, a compliance policy timeline, handbook checklists, and even sends automated emails twice a month to alert you on new legal changes going into effect across the U.S. The Reference Center is a solution that combines key employment law and HR compliance topics such as final pay, workplace posters, FMLA, minimum wage, and many others. Created to help HR, legal, and compliance professionals do their jobs more effectively and efficiently, these solutions leverage data directly sourced from Littler to ensure compliant answers and templates and information to all of your critical HR compliance needs. If you're interested in learning more, a survey will pop up on your screen. It should have about a slide ago. You may have to exit full screen mode to see it. If you'd like to receive a demonstration of the Navigator Suite tailored to your organization's concerns and risks, simply answer yes, and I will send your contact information to our team of experts. In addition to a demonstration of our solutions, you may be eligible to receive a free trial of our products so you can see precisely how much time and money they can save you. While the poll is running, you may be wondering, how do our solutions fit in with today's topic? During today's presentation, Kyllan and John will share important issues, like the new standard of workplace rules, the importance of a solid employment contract, and why it's critical to have an up-to-date and compliant employee handbook. The complianceHR solutions are designed to help you overcome many of these exact issues. If you're not sure at this time, I'll ask once more before we conclude the presentation, or you can request more information with the links on screen by visiting our website, or you can chat in the Q&A box. Now, I have the pleasure of announcing today's webinar presenters, John Harper and Kyllan Kershaw. Kyllan and John are both Littler shareholders with a strong focus on labor relations issues and identifying solutions to them, making them experts on today's topic. Kyllan and John, I'll pass it over to you.
Thank you, Stephanie, and good afternoon or good morning, everybody. Glad to have you with us today. First, let's talk a little bit about what we're going to review during today's presentation. First, we're going to talk about and review the state of union organizing. Secondly, we're going to talk briefly about the current NLRB and what's going on with them and some lawsuits that it may be facing and some efforts at the courts to maybe rein in the NLRB a little bit. Third, we're going to really spend some time talking about developments in the law at the NLRB, including the expansion of PCA or protected concerted activity, the use of authorization cards, and the NLRB's pushing of the authorization cards in order to recognize unions. new standards for the legality of workplace rules, attacks on employment contracts, and changes to the joint employer and independent contractor standards. Finally, if we have time, we'll identify some proactive steps that your organization can take to effectively address and respond to these developments. But first, the first question is, why worry about all of this? I mean, many of you may have heard some news lately that causes you to say, I don't really need to think about these issues. And one thing that you may have heard about is that the unionization rate continues to drop. It's dropped again in 2023 from about 6.1% of private sector workers being in unions to now 6%. And something else you may have heard about is that the earnings gap between union and non-union employees has continued to narrow. But we think that these are really kind of false signals, and what you're really seeing is these sorts of statistics. Union petitions are up at the NLRB by 35%, and unfair labor practice charges are up at the NLRB by 7% in the first half of fiscal year 2024. And these continue trends that have been going on really throughout the Biden administration. Secondly, unions continue to win a very high percentage, almost 80% of the representation petitions that they file. They are also increasingly engaged in national campaigns, in corporate campaigns, and in non-traditional targets like smaller retail outlets and things like that. And so a lot of times when we think about union organizing, or historically have thought about it, we think about large facilities, manufacturing facilities with lots of people that would allow unions to organize lots and lots of people all at one time. But we've really seen a shift here to unions targeting smaller locations, smaller facilities in an effort to do a ground-up organizing effort inside companies. And these trends have certainly continued in 2024. Another data point is that support for labor unions among the American populace remains near an all-time high. It was a little over 70% in 2022. It's dropped down to 67%, but that is obviously a supermajority of the American public that have a favorable view of labor unions. And within this, most of that support is in the demographic of 18-year-olds to 39-year-olds. And that's an interesting statistic as well, because that demographic has very little experience with unions, unionization, what a union means, how it can impact their workplace, and that sort of thing. And so not only do we have the statistics, but we have the anecdotal information that's out there as well. There are lots of bargaining success stories. A lot of folks have heard, obviously, about the big three bargaining that occurred this year, that the UAW has now taken out and tried to organize other facilities based on that success story. Secondly, that younger generation, that 18 to 39-year-old demographic, are very much aligned with social justice movements. And the syllogism really goes something like, unions do good in the world and we want to do good in the world, and therefore we like unions. We continue to have some persistent inflation and some questions about the exact state of the economy, which is creating some uncertainty among the workforce. We hear all the good numbers about jobs, the number of jobs increasing and that sort of thing. But when I talk to folks, and I talk to my union colleagues on the other side, and I talk to employees who are on the other side of the bargaining table, we hear a lot about a lack of job security and instability and worries about the future and worries about economics and that sort of thing. And finally, one of the biggest wins in union sales at this point is the Biden administration. And many of you all may have heard that the Biden term began with President Biden stating that he wanted to be the greatest president for organized labor that the country has ever seen. And through his appointments to the NLRB and his other efforts, he's gone a really long way to accomplishing that goal. Next, unions and union organizing and bargaining and all of those things are in the media in a way that I have really never seen in my career. Almost at least weekly, there is something going on that hits the front page with respect to labor issues. And so it really has brought this to front of mind for a lot of people in a way that it hasn't been before. Finally, I mentioned it already, but the current NLRB has made it much easier for employees to organize. and harder for employers to address employee concerns and communicate with employees. We'll talk a lot more about the ways that it has done that, but there are some pending legal challenges to the NLRB and various of its aspects. The Supreme Court just issued a case deciding against the NLRB with respect to some of its procedures a couple of weeks ago. And there are cases pending against the NLRB in various forms or fashion, attacking, whether it's administrative law judges are properly appointed. The Supreme Court is set to decide some other administrative agency cases that may limit the power of administrative agencies like the NLRB to issue decisions and the amount of deferral that they get. And so, we're at a bit of an interesting inflection point here where on the one hand, the NLRB is being very aggressive in expanding the rules in favor of union organizing on the one hand, and on the other hand, courts are beginning to take steps to try and rein the scope of administrative agencies' authority, including the NLRB's authority, in. And so now we're going to spend some time starting to talk about some specifics here, and I'll turn it over to Kyllan to talk about protected concerted activity.
Thanks, John, and nice to talk to everybody. So expansion of protected concerted activity. So one of the reasons for this webinar is a lot of times we get the question that we don't have a union or we're not worried about union organizing, so this whole National Labor Relations Act stuff doesn't apply to us, right? And unfortunately, the answer to that is no. So Section 7 of the NLRA is what grants employees certain rights, and the protections that are granted by it apply to both union and non-union employees. And Section 7, it gives employees the rights, obviously, to organize a union or choose not to, the right to engage in concerted activities to bargain, again, or choose not to. And then the one that comes up the most often in non-union workplaces is the right to engage in concerted activities for the purpose of mutual aid or protection. And we'll talk about what that means. But one of the reasons we wanted to cover this topic is that with the current NLRB, we have seen a dramatic increase in the NLRB's focus on non-union workplaces, and specifically going after employers for interfering with protected concerted activity. So what is protected concerted activity? So the protected piece of it refers to, does it involve terms and conditions of employment? So is it related to work? Well, some classic examples of that would be like discussing salary with coworkers. It also has to involve acting in concert with coworkers or acting on behalf of coworkers or to engage coworkers. So, for example, does it involve two or more people, or is it somebody on social media, saying, I want to fight, this shift change, who wants to join me? Or is it somebody who's speaking, one person, but they claim to be speaking on behalf of other people? And some examples of what this looks like, I mentioned discussing pay, complaining about a manager, requesting new safety protocols, advocating for pay increases, different shift schedules. All of these things are examples of protected concerted activity, and that's the case whether it's happening in real time or online, which we're seeing increasingly. So I mentioned that, the protected piece is whether it relates to terms and conditions of employment. The current NLRB has really stretched what it means to be work-related. So one example of a recent expansion here was in a case earlier this year where the board held that an employer violated the NLRA when it discharged an employee for refusing to remove BLM from their work apron. The employer had taken the argument that wasn't related to terms and conditions of employment, that it was a social justice issue, and so it wasn't protected activity. This board held that it was, and said that that type of complaint could be inherently concerted, and also, the employee in question had apparently filed a race complaint at some point, and so I think that helped establish a work-related connection for the NLRB, but they are definitely looking to expand the protections of Section 7 to cover political speech, social speech, and things that on their face may not appear to be work-related. Additionally, they've, in another case this year, they've expanded how far employees can go in the context of protected activity. So, employees now can be, can curse, be vulgar, engage in potentially harassing conduct without losing protection. So, we get this question a lot. They use this curse word on this social media post. Can we discipline them? And often the answer is no, because the board has held that they can go pretty far in terms of, getting emotional, animated, that sort of thing. I will flag that, they still can't, make defamatory statements. They still can't, make racist, or we would argue make, remarks that violate an EEO policy, or threaten violence against anyone. So those things are still off the table, but they have expanded for sure how far employees can go in engaging in this activity. Miller Plastics, again, this created a broad view of when a single employee's actions could be considered protected concerted activity. So it's not just, you have to look carefully at whatever the activity in question is, and is it subject to like any potential reading that you're trying to initiate group action of some kind. And then lastly, and the decision that's probably the craziest to me, the board has recently held that employees can even be engaged in protected concerted activity when advocating for non-employees. So that would include former employees, that would include interns, that could include employees of another employer if they're able to articulate some reason why advocating for those employees could somehow impact their, terms and conditions of employment. So it's, ridiculous in some ways. But the point of this is that they're really expanding how far employees are allowed to go, and making it harder for employers to, take actions to foster and, protect their culture. So I will say I've seen clients who have ultimately decided that they're going to take on the risk of NLRB litigation in certain circumstances, but, we just want to make sure that everybody is aware of how far this board has gone. And again, targeting non-union employers as well. So just to go through a scenario. Katie's an employee in the company's warehouse. One day she posts a TikTok video about her manager, Janet, saying, "Janet is the worst manager in the country. Not only is she lazy and rude, but now she's out to get me. She just told the day shift that we'd all have to do a 6-month rotation on the evening shift. Are you kidding me?" Janet shows the TikTok to HR and demands that Katie be fired. How should the company respond? Well, I'd say looking at this initially, it doesn't relate to terms and conditions of employment. And it does, right? It's talking about a shift change and shift rotation. So that's clearly related to terms and conditions of employment. Then secondarily, is it concerted? So does it involve more than one person? I think that's debatable here, but the line that is concerning is where she says she just told the day shift that we'd all have to do a 6-month rotation on the evening shift. And so I think there is an argument here that it is concerted because she used that language. And so, how should the company respond? Obviously they would want to address this, but, it would not be our recommendation that they discipline Katie for this post because of its protected nature. But, let's change it up a little bit. So what if Katie included profanity and she directed it towards Janet in a video about the same issue? Is it still protected? I think it would depend on the exact language used. Like I mentioned, just putting, curse words into a video, that alone, if it's otherwise protected, probably isn't going to remove it from protection. But if it's extremely vulgar, defamatory, threatening, then it may not be protected. The next, what if the video didn't reference others on a shift? So, in the prior post, the prior slide, her post said, right, she just told the day shift we'd all have to do a 6-month rotation on the evening shift. What if instead she said she just told me I would have to do a 6-month rotation on the evening shift and made it solely about herself? I think in that situation, it may be protected in the sense that it relates to terms and conditions of employment, but it wouldn't be concerted. And so, that would change the analysis. And then lastly, what if she complained about the shift change in person and she was rude or loud, aggressive, profane? Again, it depends on the circumstances. These aren't necessarily clear cut, which is incredibly frustrating. But, really the point is when you're facing these types of situations, the point of this is so that you're able to issue spot and understand, okay, this might be protected concerted activity. I may need to get advice or guidance on this before moving forward if I want to avoid NLRB litigation. So with that, I'm going to turn back to John to give you even more good news.
Thanks, Kyllan. And the board's efforts in the PCA, or the protected concerted activity area, are a really good example of what the board is up to generally. And that is an effort to expand and stretch the meaning of the National Labor Relations Act to try and sweep in as much conduct and to try and sweep in, as we'll talk about soon, as many employers and as many employees into the coverage of the Act as possible. Another way that the NLRB is seeking to expand the Act is how employees can go about getting a union. And they did that most significantly in a recent case called CEMEX. Now, prior to CEMEX, generally the way things worked was if employees wanted to get a union, they would have to go and get 30% at least, but usually 50 to 75% of employees to sign authorization cards or show their support for a union in some way, in some written way, and submit that to the NLRB. They could make a bargaining demand based on that if they had more than 50% support on the company, but the company could refuse and insist that an election be conducted. And then the burden would be on the union to file that election petition. CEMEX, however, completely changed the game in that regard and in another critical regard. And so first, under CEMEX, when a union demands recognition now as a representative of majority of employees in the appropriate unit, the board says the employer must either recognize and bargain with the union or file its own petition to test the employee's support for the union. And so this is a very big change. Prior to this, again, as I said, all an employer had to do was reject the bargaining demand, and then the burden was on the union to move forward and file an election petition or not. Now, once the union makes that demand for recognition, the burden is on the employer rather than the union to either accept the recognition demand and move forward and bargain with the union or to file its own election petition. If it does not file its own election petition, and if the union does not file its own election petition, then the employer will have committed an unfair labor practice by unlawfully refusing to bargain with a union designated by a majority of its employees. As that case winds through the system, the result of it would be a bargaining order against the company. As a practical matter, and Kyllan, I'm curious to hear your experience on this so far, most unions, even under CEMEX, after making the bargaining demand, are moving forward and filing their own election petition because, A, they don't want to wait for the employer to do it. The employer usually has like 14 days to file that election petition once it receives the bargaining demand. And B, they don't want to run the risk of protracted litigation to get a bargaining demand after 2 years of litigation as opposed to getting to an election within 28 days or so. And so, Kyllan, I don't know if you have any thoughts on that.
I've seen the same experience since this case. I've only had one demand where the union didn't ultimately file its own RC petition. And usually, at least to me, it's often the same day or the day after. So they're ready to go.
Yep. And so, while this aspect of CEMEX presents certainly some challenges for employers, we don't think it's the most significant part of CEMEX for reasons I'll discuss in a second. But what it does mean is that employers need to be aware of a couple of things. Number one, that demand for recognition will come in writing, and it could come in writing via email to someone in your organization. And in my experience, this is not typically coming to a frontline supervisor. It's coming to an HR manager responsible for the facility or a general manager responsible for a facility. But your folks need to be aware that, if they receive something like this, they need to get it into the hands of the people that can address the issue quickly, because there is not a lot of time. Secondly, what this means is that previously, it was never a good thing to get a union election petition, but you had some space and some ability to try and, talk to your employees about the pros and cons of unionization and that sort of thing after that petition came, and still have a chance for success. Really, what CEMEX has done, and for reasons, again, we'll discuss in a second, is it has shifted this battle to the authorization card battle. And so the game now is whether unions can get a majority of authorization cards, because once they have that majority of authorization cards, they now have a lot more options to get a bargaining order against the company than they did before. And so this case really heightens the need for employers to be engaged with their workforces and understand what's going on, because they're going to have to be, sensitive to authorization card drives and able to quickly respond to authorization card drives. The more critical part of CEMEX, in my opinion anyway, is the impact that it has on unfair labor practices committed during the course of a union organizing drive. And so under CEMEX, even if an election petition is filed by either the union or by the company, if the company commits even one unfair labor practice that could negatively impact the outcome of the election, and so think broadly published unlawful rule, for example, or think a broadly published unlawful statement by a supervisor, the union can rely on the authorization cards that it obtained, those 50% plus one of the authorization cards, and ask the NLRB to withdraw the election petition and order the company to bargain with the union without an election. This is a second huge change in the law, because under the prior law, the unfair labor practices that would merit a bargaining order like that had to be severe and pervasive. Now we're talking about one, potentially. And this is another reason why once those authorization cards are starting to get gathered, that is the time to respond, rather than waiting until an election petition is filed. And that is also why it's critically important to be engaged with your folks. And the CEMEX bargaining order applies to unfair labor practices that are committed before, during, and after the critical period, namely before, during, or after that election petition is filed. And so once that card drive starts, that's really when, if an unfair labor practice is committed during that drive, it could potentially result in a bargaining order without an election. So what is the impact of CEMEX? And the result is going to be more unionized workplaces. And ALJs in the last 2 months or so have, in fact, issued CEMEX bargaining orders in situations where, a company has committed unfair labor practices during the course of an organizing drive. And so if the union gets a card majority and the employer fails to respond to that card majority by filing its own election petition, or the union doesn't file a petition, then you're going to wind up with a bargaining order. If a union gets a card majority and the employer refuses to bargain but does not file its own election petition, you'll get a bargaining order. If a union gets a card majority, the employer files an election petition a month later, outside that 14-day window, you're going to get a bargaining order. And if the union gets a card majority, the employer files its own election petition, or the union files an election petition, but the employer commits an unfair labor practice that could negatively impact the outcome of the election, you're going to get a bargaining order. If there is any silver lining in this, it's that NLRB litigation takes a really long time, and that bargaining order is not going to become effective and final for a couple of years. But the fact of the matter is you're going to be in that litigation. You may wind up with a bargaining order at the end of it. And in the meantime, it's hugely disruptive. So is SimX here to stay? SimX is being applied by the NLRB retroactively to all cases that were pending at whatever stage. Just as a war story, I have a case that's been pending since 2022. And the NLRB, we actually agreed to hold a rerun election in that case to resolve some objections. But the region is now taking the position that despite the objections having been released or agreed or waived, and the union having lost the rerun election, the pending unfair labor practices merit a bargaining order 2 years later. And so it is definitely being applied retroactively and in ways that are surprising, and that's certainly going to be a source of challenges to this case going forward. SimX did have a strongly worded dissent, and there is an appeal to it pending in the Ninth Circuit. But the way the NLRB decided this particular case is it said, in the case of SimX, a traditional bargaining order was warranted because so many unfair labor practices were allegedly committed on the one hand. But, even if a traditional bargaining order were not warranted, a SimX order would be warranted. And so there's a path there for the Ninth Circuit to duck the SimX issue by saying it was dicta and just deciding the case on the Gissel order. And so, whether the Ninth Circuit disposes of it, affirms it, or ducks the question remains to be seen. But even if the Ninth Circuit rules that SimX was improperly decided, the board does not necessarily have to respect the Ninth Circuit's decision and can continue applying SimX until the Supreme Court tells it to stop. And so unless and until the NLRB itself reverses SimX, we're going to probably be dealing with it in some form or fashion going forward. And with that, Kyllan, I'll turn it over to you for employer policies.
Thanks, John. So employer policies and work rules. Again, similar to the protected concerted activity, this is an area that the NLRB has used to target non-union employers. I will just say anecdotally before I get really into it, nowadays, pretty much any ULP charge that I see filed, and I would imagine John would say the same, they will try to get a copy of your full employee handbook, whether it's relevant or not, and use it as a basis to try and file more charges. So that is something to be aware of, and would recommend, consulting counsel before you were to turn over your handbook, because they are looking at them closely. And part of the reason for that is, there was a decision in 2023. So the war on handbooks isn't necessarily new. The Obama-appointed NLRB was relatively aggressive on employee handbooks. And then the Trump-appointed NLRB, in a decision called Boeing, overruled a lot of the Obama board era standards and made it to where it was much easier for employers to maintain lawful handbook rules. Unfortunately, in 2023, Boeing was overturned and replaced by the rule that's now Stericycle. And under that case, basically a facially neutral rule is, presumptively unlawful if an employee could interpret it to limit employee rights, regardless of whether there's a lawful alternative interpretation. And so under this standard, it's not judged by the perspective of a reasonable employee. It's really more, is there any way I can read this that's unlawful? And if so, it's going to be found unlawful. Even if, again, there's an alternative interpretation that's more logical and, So it's a very frustrating rule in that way. The intent of the employer is likewise immaterial. So even if the employer had absolutely no intent of restricting Section 7 rights or genuinely didn't understand that there was a way to read it that would restrict Section 7 rights, it's still unlawful under the standards of this case. And to defend a rule as an employer, you have to prove that the rule advances a legitimate and substantial business interest and that you're unable to advance the interest with a more narrowly tailored rule. It's very aggressive, the standard. And hold on, my slides are not advancing. I apologize. 1 second. There we go. Okay. So the types of rules that are in the board's crosshairs, honestly, the short version of the answer is all of them, but the ones that they are focusing on primarily, civility rules. Again, this was also a focus during the Obama era board. Rules requiring employees to be respectful and courteous at all times. Those are generally considered overbroad and unlawful. Rules prohibiting, even rules prohibiting harassing, disruptive, and insubordinate workplace conduct. They have been taking a much closer look and being much more aggressive with respect to those rules. No recording or photography rules. And this is something that I feel like is coming up a lot. Employees are increasingly trying to record meetings with supervisors, conversations, and so forth. And, the board is aggressively pursuing policies that prohibit employees from engaging in recording. Rules, regulating the use of the employer's name, and that often comes up in a social media context. And then in addition, rules restricting speaking to the media or the third parties, conflict of interest rules, rules regarding disparagement or criticism of the employer, and confidentiality rules. So, if the rules include things like terms like employer business, employee information, handbooks, or other references to terms of employment, it's likely that this board will find it unlawful. And to be lawful, a confidentiality policy has to be restricted to things like, trade secrets, customer information, and things along those lines. And you generally have to have, or we would recommend, some disclaimer language there as well, saying that it's not intended to restrict Section 7 activity. Some other rules that this board's paying attention to, the General Counsel, include dress codes. Specifically, can you prohibit employees from wearing, like the BLM apron example that I gave earlier, social media, off-duty misconduct, misconduct towards management, and confidentiality of investigations. So, telling employees that they must keep an investigation confidential will be found unlawful by this current board. And, despite whether these rules being, unreasonable, the General Counsel is seeking a lot of expanded remedies for these types of violations. She's urged the board to issue a make-whole remedy for illegal work rules, and go back and essentially expunge records and reinstate and issue back pay for any employees disciplined under an unlawful work rule during the prior 6 months, even if the employee isn't identified in the charge or the investigation itself. And it's, a recipe for lengthy compliance litigation. So, in terms of takeaways, reviewing the handbook with Stericycle in mind. One big tip is identifying the business reasons for the policies. And I would recommend even doing that in the policy itself, right? If there is a legitimate business reason why you need this policy, stating that up front in the rule will help make it more defensible. Again, considering a narrowly tailored disclaimer, that the rule in question is not intended to interfere with an employee's Section 7 rights, And then, unfortunately, they have made it so difficult to maintain lawful handbook rules that, we would generally recommend engaging experienced labor counsel to help you find a balance between, the rules that you need and how to avoid running afoul of this board. And with that, I'm going to turn it over to John to talk about employment contracts.
Perfect. And so a couple of things under employment contracts that you guys have probably all heard about or heard rumblings of with respect to the NLRB is, number one, the McLaren-McCombs decision that talks about confidentiality and non-disparagement provisions in severance and settlement agreements. And number two, the board's effort and the FTC's greater effort to ban non-competes. And so first, with respect to McLaren-McComb, many of you probably have already dealt with this, but in McLaren-McComb, the NLRB overturned two decisions that permitted employers to include confidentiality and non-disparagement provisions in severance agreements. Now, the board had, for a long time, regulated non-disparagement and confidentiality provisions in non-board settlements related to unfair labor practice charges. And so it had issued what they call an operations memorandum back in 2007, I believe, that said, if you're going to settle an NLRB charge, and that settlement's going to have confidentiality and non-disparagement in it, the confidentiality must be limited to the financial terms of the settlement, and the non-disparagement must be limited to basically the legal definition of non-disparagement, statements that are maliciously false or untrue. Effectively, what the NLRB did in McLaren-McComb is expand that operational guidance for NLRB settlements to all other settlements on a theory that anything beyond, that very limited confidentiality and that very limited non-disparagement prohibited employees from going out into the world after their employment with you ended and engaging in PCA with other employees based on their terms and conditions of employment with you. And a lot of that grows out of the very broad definition of employee under the National Labor Relations Act, which is an employee is an employee of an employer, not of a particular employer. And so your former employees can theoretically come back and engage in protected concerted activity with your current employees and still receive the protection of the Act. So again, the theory is that confidentiality and non-disparagement agreements violate Section 7 because public statements by employees about the workplace are central to the exercise of employee rights under the Act. Merely offering an agreement with these unlawful terms is an unfair labor practice. And so I've litigated a couple of these, and effectively what the NLRB attempts to do is to rescind the specific provision at issue. It reaffirmed that restricting access to the board is also unlawful. Finally, General Counsel guidance indicates that she would apply the same concepts to other agreements like settlement agreements and arbitration agreements, general employment agreements. And so, in some situations, you may have an at-will employment agreement that sets out certain confidentiality obligations and that sort of thing. And McLaren-McComb would apply to that. And in fact, moving to, so what do we talk about when we talk about McLaren-McComb and managing risk? First, no settlement agreement fits every single situation. And so confidentiality in one situation may not be the same as confidentiality in another situation, but that confidentiality provision should be limited to trade secrets and other proprietary information. Limit confidentiality in a settlement agreement to the financial terms of the settlement agreement, and limit non-disparagement clauses to maliciously untrue statements. And so under McLaren-McComb, it's not that you can't have these provisions, it's just that they need to be narrowly tailored. Secondly, in your settlement and severance documents and in your other agreements, consider looking to include appropriate disclaimers along with other protected rights. And so include a reference to rights under Section 7 of the National Labor Relations Act, for example, and include a reference to rights under Title 7 and the employee's right to file charges not only under the National Labor Relations Act, but with the EEOC and other agencies that would investigate such things. With respect to retroactivity, notify employees that overbroad provisions in earlier agreements won't be enforced, or provide an amended agreement. And finally, ensure there's a severability clause in the agreement that says if any provision of the agreement is held unlawful, the remainder of the agreement remains in place. The end of the day, a lot of the severance agreements that I deal with, the three major things there are getting rid of the litigation or releasing the litigation and, making a consideration payment. And so, the confidentiality, while important, is usually somewhat secondary, and the non-disparagement is really meant to be a prophylactic to try and discourage employees from, going out and saying negative things about the company. And so, I view this as process in the sense that we need to make sure we get the right language into the agreements. But at the end of the day, I don't necessarily view it as hugely substantive in the sense of what these agreements are trying to accomplish, which is a consideration for a settlement and release of claims. Next, with respect to non-competition agreements, the General Counsel issued General Counsel Memorandum 2308, announcing her intention to urge the NLRB to declare all non-competition agreements unlawful with limited exceptions. And in fact, just this morning, I received notification in my email that an NLRB ALJ has ruled a non-competition agreement unlawful. And the way that she got there was, number one, it violated Stericycle, which is the case that Kyllan just discussed, because the non-competition agreement might dissuade employees from doing things like encouraging each other to quit their jobs in an effort to protest working conditions. And because it might also make employees, quote, fearful of rocking the boat, close quote, because they won't be able to get another job if they do. And so you can kind of see how broadly the NLRB's ALJs, with the encouragement of the NLRB's General Counsel, are interpreting Stericycle and using it to attack things that you might not think about. Secondly, the ALJ held that the non-competition agreement violated McLaren-Lacombe because it would encourage employees from refrain from engaging in protected concerted activity after their employment ended, which is the point that I just made. And so, thirdly, many of you probably have already heard about the Federal Trade Commission rule banning non-competes. And so, in some ways, they beat the NLRB to the punch on this, but that FTC rule doesn't take effect until August, if it takes effect at all, given the challenges that are pending. And the thing with the NLRB is it will continue to pursue its theories on this, regardless of whatever happens with the FTC rule. And so as you move forward, a place for you guys to take a look at in terms of your practices and your operations is, do you have non-competes in places and purporting to bind employees where you don't really need them? Keeping in mind that the National Labor Relations Act does not apply to supervisors and managers necessarily. It applies to frontline employees. And finally, Kyllan, I'll turn it over to you for joint employer.
Okay, so joint employer and independent contractor. So these are, again, examples of the NLRB attempting to expand its reach. So the joint employer rule, what is the board's current stance? They've passed a rule that would make more businesses joint employers, very similar to the standard that was in Browning-Ferris under the Obama board. If you feel like you're playing ping pong, you're not alone. This is the third change in only 3 years. And under this test, you're a joint employer if you have indirect or reserved control over certain essential terms and conditions of employment. And the key with the indirect or reserved control is it applies even if it's not exercised. So, for example, if you have a staffing agreement that gives you the right to potentially weigh in on discipline, that could be cited as evidence that you're a joint employer, even if you've never acted upon that rule. So, why does joint employment matter? Why do we care? So joint responsibility for labor law requirements. So, if you have a staffing agreement and, the other party, whether it's the user employer or the supplier, is, engaged in unlawful activity, you can be found jointly liable. And you can also be brought in organizing. So, a union could try to organize both you and the other party's employees on a joint employer theory. and you could potentially have to engage in joint employer, multi-employer bargaining with the union. So, again, this doesn't just apply to unionized employers, and it really, the reach is pretty far. If you have employees that, and you work with vendors like a staffing company or a management contract, you could be a joint employer under this rule. So, right now the rule's legal status is uncertain. The rule was originally scheduled to take effect on March 11th, but a few days prior, the Eastern District of Texas vacated it, as well as the NLRB's rescission of the 2020 rule. And the NLRB is appealing that ruling to the Fifth Circuit. And there's also a lawsuit by the SEIU and the DC Circuit. Joint employment, it is still a concern under the NLRB's prior 2020 rule, although that is a much more business-friendly standard. So remains to be seen whether or not this rule that makes it easier to be found a joint employer will take effect. And I'm just going to turn it quickly over to John because I know he had a point he wanted to make on this issue.
Yep. And so really with respect to the joint employer piece and the independent contractor piece, I think what you see here is the NLRB trying to get as many employers on the hook for things as possible. And so, when you think of joint employer, what you think of is you've got two employers, two potential companies managing in some form or fashion one group of employees. And so the thing you need to be thinking about is, what does that look like inside our organization and where are our pressure points? And, what, if anything, do we need to be thinking about trying to resolve that? And so a common place is temporary employees, right? If your facility uses temporary employees from a user employer, what is your control over those temporary employees and what sort of vulnerabilities are there?
All right. Thanks, John. And moving on from joint employer to independent contractor status, again, very similar to what John was just talking about. The board is trying to make as many people employees as possible so that they have jurisdiction over them. As you know, the NLRA doesn't apply to independent contractors. And so the Trump board had a decision called Super Shuttle, which had made it much easier for a worker to be found to be an independent contractor as opposed to an employee. This board overruled that last year in the Atlanta Opera decision, and under that test, it's going to reclassify a lot of individuals who were previously independent contractors under the Super Shuttle standard as employees. And in addition to that, there was a decision, Velox Express, so it was a Trump board decision, and it held that an employer misclassifying an employee is not a standalone unfair labor practice. And so we just wanted to flag that there is a case pending before the board to reverse that. And I think, it would be our expectation that this board will reverse that, making misclassification a standalone ULP. So, it's just something to pay close attention to in terms of how your workers are classified. And with that, I think I turn it back to Stephanie.
Yes, John and Kyllan, thank you so much for providing us with this in-depth look at all of the labor and employment laws that our attendees need to know about. While you both take a moment to read through some of the questions that have already been submitted by our attendees, I would like to take the opportunity to offer another chance for you to sign up for a demo of the complianceHR Navigator Suite. So if you're interested in learning more, the survey should pop up on your screen, but you may have to exit full screen mode to see it if you are in full screen mode. If you'd like to receive a complimentary demo of the Navigator Suite, which covers crucial topics like independent contractor classification evaluations, employee overtime evaluations, employee handbooks, and rapid reference resources, along with so many other topics, then please select yes to the poll, and I will send your contact information to our team of experts. If you're not interested at this time, you can select no, or you can just ignore the poll. John and Kyllan, did you find any questions that you'd like to respond to today?
I am taking a look right now.
Amazing, thank you. Well, the poll is still open, so everyone who is interested, please respond. Otherwise, I will pass it back to you two.
Perfect. And so here's a question about whether a company can challenge the unit in CEMEX organizing attempts. And the answer is that they can during the unfair labor practice litigation. And so, for example, part of an employer's defense to refusing to recognize a union would be that the unit is inappropriate, and that would be carried with the litigation. Otherwise, if it filed its own our case petition, or if the union filed its own representation petition, those unit issues would be handled in the normal course of business. Let's see. Another question, is the definition of majority still 30%, or is it a true majority of the bargaining unit? And so with respect to that issue, the statutory minimum for a union to file an election petition is that 30% of employees in an appropriate bargaining unit support the union. In order to get a bargaining order and to fall under the CEMEX framework, you have to have a majority of employees that have expressed their support for a union in an appropriate bargaining unit, because a necessary predicate to a bargaining order is majority status. And so if there is no majority status, there is no CEMEX issue, but there could still be an election. But that's why that card drive now is so important, because if they get to that majority status point, the game changes. And so you really need to be, and this was going to be one of my takeaways, is in light of kind of all of this expansion of PCA, and in light of CEMEX, and in light of, the work rules that we've talked about, you really need to be engaged at a frontline level, from your supervisors to your frontline employees up through, your management structure, to understand what's going on with your folks on a day in and day out basis. Because, if you don't know that a card drive is going on, or if you don't know that there is an issue in a certain place that could lead to a card drive, you're really starting out behind the eight ball. Kyllan, I don't know if you have any concluding thoughts.
Yeah, I was going to respond to one quick question, which was, with regard to social media posts, does it matter whether or not other employees like the post? I think that's a very good question. I would say that it definitely does. If other employees are liking or engaging with the post, even if the post itself didn't appear to be concerted, if it's, resulting in, employees engaging on the issue, then, the employer would definitely face increased risk for discipline. I'd say in terms of the takeaways, obviously I agree with everything that John said. I think the only thing that I would add is this can be very overwhelming, all of these different rules and standard changes, and, makes it feel very difficult to maintain your culture, run your business the way that you would like. And so, ultimately it really is a question of risk tolerance. And, so I just want to point that out there. There is a lot of risk here. But, if you work with legal counsel, you may be able to, work around some of these rules, or accomplish your goals in different ways that are NLRA compliant.
Perfect. And I see we are really right about at time. And so just wanted to thank everyone for joining us this afternoon or this morning, wherever you are. And our contact information is in the presentation. And so if you have any follow-up questions, I know we'll get a list of additional questions. But if you have any follow-up questions or would like to discuss any of these matters, please feel free to reach out to either one of us, and we would be happy to chat with you. So thank you, everyone, very, very much.
Thank you.
Thank you all for attending, and thank you, John and Kyllan, for the great content. I'm sure we all very much so appreciate it.